It's a duty to do X, which then entails a right to do Y. I have a duty to serve under these circumstances with a firearm, and therefore I have a right to get my hands on this firearm and to keep it, and no public official can stop me from doing that because he can't interfere with my constitutional duty. In fact, he has to help me fulfill my constitutional duty.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for March 11th through March 18th, 2024, while supplies last. First, we feature 90% junk silver mixed dimes and quarters at just $1.99 over spot. We also have AU pre-1933 Gold Liberty at $65 over a 1-ounce spot. And finally, we're offering our choice 1-ounce palladium bars at just $119 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.
So that's that. Now, the other topic we had kind of falls into that in the same way. It's a kind of lawfare in a different sense. Legislative lawfare. You got all over this country statutes enacted in some places, Portland, Oregon, Seattle, Washington, California, New York, Illinois, very liberal states, and proposed to ban what they call assault firearms or assault weapons and what they call high-capacity magazines. And generally they're talking about things like the AR-15s or clones of the AR-15s, the AK-47s to a certain extent, clones of them, all semi-automatic firearms. And then any magazine that's over 10 rounds or 12 rounds, depending on what your statute you're looking at. And then they go further in some places where they write statutes that pretty much ban any kind of semi-automatic firearm. And then there are statutes that, I saw one example the other day. I think it was in Oregon. The firearm that the fellow was using as the example under this statute was a model that had been created in the late 1800s. Model in 1880s, 1890s, whatever, but it's a very old lever-action gun with a long barrel, obviously designed for hunting large critters. And it had, the lever-action firearms have a magazine tube that runs underneath the barrel. And this particular one had a tube that would take 15, I think it was, of the particular cartridge of that day. And today as well, obviously, but it was designed 15 rounds at that time. And he said, well, under this statute, I think it was either proposed or it's already been voted, whatever, it's very close to passage, that would be an illegal assault weapon because it had a high-capacity magazine. And it's designed from the 1880s. There are probably very few of them even in existence. All right, so that's we're talking about, in a sense, madness. Now, here in Virginia, in the last election, when the red wave was supposed to sweep across the country, well, in Virginia, the blue wave swept across the country. And the legislative elections put the Democrats back in control of the Virginia House of Delegates and the Virginia Senate, Virginia General Assembly in total, by a few votes. And they were enabled to enact, on party lines, of course, a number of gun control bills. And the one that come to mind, they got a couple of gun control bills to deal with these assault firearms. And so there are two things that interested me about this whole business. Number one, what I call the short-term problem that we have with the Second Amendment, of how all the Second Amendment advocates really don't know what they're talking about. And then number two, the really long-range problem that if they did know what they were talking about, the resulting consequence in governmental action would be something that would be very favorable to turning a lot of this country around. And what I mean when I say they don't know what they're talking about, they always defend these statutes. The statutes are all the same. They define an assault firearm as a rifle or pistol which has semi-automatic, detachable box magazine, hand grip, perhaps a folding stock or telescoping stock, a barrel that's threaded to receive a suppressor or a muzzle brake, or maybe it just has a muzzle brake, and maybe it has a bayonet lug. And the whole theory of this is, well, these are, quote unquote, weapons of war. This is the mantra, the political mantra. They're weapons of war. And in fact, there's a case that makes, one of the early cases that makes this out explicitly, the Colby versus Hogan case in the Fourth Circuit, en banc case. I mean, the whole Fourth Circuit panoply of judges looked at it wrongly, came to the wrong decision. And that was their contention. They said, well, these things are akin to weapons of war. No, they're not automatic. They're semi-automatic. And no, they're not the guns that the Army's actually using now, but it used to use them, so similar guns. And therefore, they're weapons of war. And the Second Amendment does not protect weapons of war. And it said this, actually, this shows you the perversion, which I'll get into the system. They said this, well, this is on the basis of the District of Columbia versus Heller case, because in the District of Columbia versus Heller case, we find the statement by Justice Scalia in his majority opinion that what they're saying in that opinion is not going to cover necessarily various kinds of weapons, M16 rifles and the like. That's the quote, M16 rifles and the like. Well, these assault firearms or assault weapons, which are found in the state statutes, in the Colby case, there's a Maryland statute, and then, I mean, more recently, other state statutes, they are clearly not M16 rifles. There's a big distinction between an M16 rifle and all of these AR civilian variants. But it's and the like. And so they had experts in the Colby case for the state of Maryland say, well, look, they all have, they look the same, they function the same, they use the same cartridge, they use the same magazines. Well, what's the difference? It's just that this one doesn't shoot fully automatic or automatic. It just shoots in semi-automatic, but you can pull the trigger pretty fast, and you get off those 30 rounds in whatever number of seconds, and okay, it's not pumping them out as a machine gun, but nonetheless. And so they got the court to agree to that theory. And the opponents of this said, well, these guns are protected by the Heller case because they're useful for home defense. Well, maybe yes, maybe no. Possibly yes, possibly not. But the proponents of this, Second Amendment proponents, have gone to great lengths to try to prove that they are, that this is the consequential thing, that they can be used for home defense. Well, if you look at the one case that actually talks sense about this from the Supreme Court, United States versus Miller. The question in that case was whether a short-barreled shotgun that had a barrel less than 16 inches long, was protected by the Second Amendment or not. And the Supreme Court goes and says, well, what's Second Amendment about? Let's go back to the history, look at the colonial period. Every individual had to be armed. Actually quotes a Virginia statute as well as a New York statute. They had to bring their own guns. So that was the essence of the thing. It was the armed citizen with his own gun that would be called out to perform whatever militia functions might be necessary. And then it defines what these guns would be. Well, they were guns that could be used for militia purposes, for the common defense, and so forth. And they're all definitions that would fit military or paramilitary activity. Why? Because if you look at the basic purposes of the militia, it was always what the Constitution recognizes as the reasons that the Congress can provide for calling forth the militia. Execute the laws of the Union, if Congress is doing it, or execute the laws of the state, if the state is doing it. Suppress insurrections and repel invasions. Well, if you think of an invasion, it's some foreign army. They're not going to be armed with slingshots. They're going to be armed with, as far as they're concerned, the latest and best in armament for the infantrymen, which is what the militia basically are. And so you would think, well, right there, a person who was potentially subject to calling the militia would be told to have a weapon of war. All right? So on the face of it, if you look at that opinion, you'd say, well, all of these assault weapons bans are Clearly a violation. Look at Virginia as an example. You want to connect the militia to this. Virginia. Militia of Virginia consists of, this is a statute, says this, the militia of the Commonwealth of Virginia consists of all able-bodied residents, male or female, from 16 to 55 years of age. And it includes all aliens who have made whatever steps they need to take to become a citizen. And it's broken down into three components. The National Guard, I'm not going to get into the National Guard. That's not a militia. That's something else. You have to study the history of that. Virginia Defense Force is a very small group, less than 700 now people. And that's actually an adjunct of the National Guard. And then something called the unorganized militia. That's everybody else. Last time I did a calculation a couple of years ago, it's over 4 million people. And it's from 16, not from 21. All right? And most of these gun laws, they don't allow someone less than 21 to buy a handgun. They don't allow someone less than 18 to buy any gun. May possess one. The father gives the shotgun to the son, go hunting. But the gun can't, the son under 16 years of age, under 18 years of age, he can't go into a gun store and buy from a federal licensed gun dealer a shotgun or a rifle. He certainly can't buy a pistol. Not in Virginia. And under these new laws, they can't buy a so-called assault rifle. Anybody can't buy an assault rifle. So in any event, here's this huge population. And in Virginia, the governor has the authority actually to call out anyone over 55. So I'm over 55. And the governor could call me up forth. And then I'd be drafted. And I would become a member of the unorganized militia by hypothesis, the only place I could go. And if I didn't show up, you know what would happen? I'd be court-martialed. Specifically says so in the statute. So we're talking about a serious matter. The governor also has the power under the Virginia law to provide for arming and training members of the militia, and to provide for the members of the militia to use their own personal property for their militia service. And what is that? Well, that's the way the militia always ran. You had to have as personal property various things, including some kind of firearm. And then that's what you use when you were called out. So it's the basics are still there in Virginia. The problem is that it's not fleshed out by anything. Yeah, the statute's there, and if you go and look and say, well, are there some kind of regulations that the Department of Military Affairs, the Adjutant General, the Governor's Office, whomever, has laid out to have this done? The answer is no. They just let it go. Well, why have they let it go? Well, because those people in the unorganized militia from 16 to 55 and older, such as myself, have not brought pressure on the legislature, on the governor, to provide for a true militia structure. It's as simple as that. It doesn't exist. It exists on paper, exists in theory, but it doesn't exist in practice. And this is actually a violation of the Constitution of Virginia, Article 1, Section 13. It says that a well-regulated militia composed of the body of the people, that's 16 to 55, that's certainly the body of the people, most of the people, trained to arms. The body of the people trained to arms. Well, where's the training? Where are the arms that are appropriate to training for the militia? Well, not there. Is the proper, natural, and safe defense of a free state. Therefore, the right of the people to keep and bear arms shall not be infringed. Notice that therefore, the right of the people to keep and bear arms is a consequence of this other thing, that a well-regulated militia is composed of the body of the people trained to arms. It's not the other way around. That's where the right to keep and bear arms is fixed. To this duty that all people within this category, the body of the people, Virginia 16 to 55, actually have a duty to perform this function. And the duty's right there in the statute we have now in Virginia, because the governor can call these people out, and if they don't show up, he can call people out to repel invasions. You think about that for a second. In comparison to the so-called individual right to keep and bear arms. Individual right to keep and bear arms is always predicated upon the argument of self-defense. I'm trying to protect my life or my bodily integrity from some person that is threatening it with imminent violence. And under those circumstances, I can respond perhaps even with deadly force, if that is appropriate, given the circumstances. Well, now think about the governor calling people out to repel invasions. By hypothesis, that's a situation where you can lose your life. Self-defense is not an argument there. You can be killed. You can be horribly maimed and crippled. You can be driven insane, post-traumatic stress disorder, right? All these terrible things can happen to you as a consequence of your being called to your militia duty. Well, what the heck does that have to do with an individual right to keep and bear arms? That militia duty is not concerned with your miserable life, if I may put it in a very blunt way. It's concerned with the salvation of the social system and all that it entails. We're talking about individual liberty, economic freedom, et cetera, right? We're not talking about some communist state. But that's the consequence of this system. It's a duty to do X, which then entails a right to do Y. I have a duty to serve under these circumstances with a firearm, and therefore I have a right to get my hands on this firearm and to keep it, and no public official can stop me from doing that because he can't interfere with my constitutional duty. In fact, he has to help me fulfill my constitutional duty, which in Virginia the governor has not done. All right, but let's get back to these assault weapons bans. So they're all invalid on the face of it because the guns that they define are the guns that fit not only the United States versus Miller definition, but the common sense definition of a firearm that would be useful for repelling invasions or suppressing insurrections, because sometimes insurrections, they result in very wide. Look at what happened in 2020, the burning down of various cities, looting and so forth, arson and all the rest of it, all right? And then executing the laws. If you ask the police, you go look at a police cruiser today, sheriff's cruiser. In the old days, they used to have a pump-action shotgun, Remington 870, maybe a Mossberg, whatever the model was, equivalent. Today, they all have AR-15s. And what do they call them? Do they call them assault rifles? No, they call them patrol rifles. Very interesting, right? They call them patrol rifles. And in many cases, they are automatic, not just semi-automatic. Depends upon the department. All right, but there they are. So that's executing the laws, right? That's what the police are supposed to do. By the way, the whole police structure in this country has a very dim constitutional basis. The militia should be doing that. These police departments should all be subunits of the militia. And then, oh, by the way, we wouldn't have problems with police unions. We wouldn't have problems with internal affairs covering up police misconduct. We wouldn't have all sorts of problems that we see in these police departments because the militia structure would run them in a much more disciplined and controlled manner. But I'll leave that aside. In any event, you look at the police executing the laws, you look at suppression of insurrections that rise to the level of arson and looting and tearing down cities, and certainly if you look to repelling invasions, you're talking specifically about the modern firearms that all these statutes call assault firearms or assault weapons, quote-unquote weapons of war. Well, an invasion, I guess, would constitute a warfare situation. Now, that's what we were talking about earlier, right? I could talk about that with respect to the border in Texas. Article 1, Section 10, Clause 3, no state without the consent of Congress shall engage in war unless actually invaded. Right? States have a explicitly reserved constitutional power to engage in war when actually invaded. So invasion and war seem to be connected in some way in the minds of the founding fathers. So one would think, if you're talking about weapon of war, you're talking about invasion, you're talking about the duty of the militia to repel invasions, and you're talking about the duty of the individual to be trained to arms, if he's within the body of the people who are the form of the militia, then it would pretty much follow as axiomatically, apodictically, if you will, with absolute philosophical precision, unable to be refuted, right? That these assault weapon bans are all unconstitutional on the face of it. They're certainly unconstitutional in Virginia. We got a couple of these bills coming in front of the governor now. He's probably going to veto them because he's a Republican. But they're clearly unconstitutional in Virginia. And they're clearly unconstitutional under the Second Amendment because the United States versus Miller decision was a Second Amendment decision as opposed to an Article 1, Section 13 Virginia Constitution decision. So they're unconstitutional across the board. And in Virginia, by the way, the Virginia courts have said that Article 1, Section 13 is the same has the same effect as the Second Amendment and vice versa. So we're all in this. Everybody's in the same ballpark on this when they actually look at it. So you look at all these statutes, say they're all unconstitutional. The next level is, well, wait a minute. Unconstitutional under the Second Amendment, unconstitutional under Article 1, Section 13. Okay, fine, that's all well and good. But there's another interesting quirk to this that most people don't ever pay attention to. There's a very old case, Presser versus Illinois. People can look this up, because I'll tell your audience what it is, because they'll never find it on their own. Presser versus Illinois, volume 116 of the United States Reports, page 252, 1886 case. And on page 265, the court makes this interesting observation. It says, it's undoubtedly true that all citizens capable of bearing arms constitute the reserve military force or reserve militia of the United States as well as of the states. All right. All citizens capable of bearing arms, 16 to 55 plus in Virginia, right? Able-bodied citizens. And in view of this prerogative of the general government, that is the government of the United States, as well as of its general powers, the states cannot, even laying the Second Amendment out of view, prohibit the people from keeping and bearing arms so as to deprive the United States of their rightful resource for maintaining the public security and disable the people from performing their duty to the general government. Well, what duty is that? Constitution. Article 1, Section 8, Clause 15, Congress has the power to provide for calling forth the militia, execute the laws of the Union, suppress insurrections, repel invasions. There's the duty. And then Congress has the power to provide for organizing, arming, and disciplining the militia. So what Congress has done so far is to kind of leave that alone. It doesn't provide for directly for arming members of the militia, the people it would call up, or who are by statute from 17 to 45 years of age. All right, a little less than the Virginia range, but the same concept. But what does Congress do? Well, Congress lets people go out and buy these guns. There's no provision in the federal firearms laws that prevent people from buying these guns or federal firearms dealers from selling them, transporting them into the state and so forth and so on, which the state anti-assault firearms laws do. So one would look at that and say, oh, these things not only, the state statutes, not only violate the Second Amendment and whatever equivalent provision there is in the state constitution, they violate Article 1, Section 8, Clauses 15 and 16. Presser versus Illinois case says that. The states can't do this. Right? Even laying the Second Amendment out of view, the states cannot prohibit the people from keeping and bearing arms so as to deprive the United States of their rightful resource for maintaining the public security and disable the people from performing their duty to the general government. So here we have, say, in Virginia, this statute actually applies only to assault firearms that are made after July of this year, 2024, because otherwise they get into a hell of a problem with confiscation and so forth and so on. But after that date, there are a lot of people who won't be able to buy an assault firearm in Virginia because the statute doesn't allow them to buy them. Well, what if they're called up by Congress because the Chinese Women's Liberation Army is invading the United States across the southern border? They won't have guns, will they? No. They'd be in violation of the Presser Doctrine. 1886, thank you. Wasn't decided yesterday. All right, so why are we in this mess? And then we'll get to the real consequence of the mess. We're in the mess because of the Heller case, District of Columbia versus Heller. And then its clone at the state level, the McDonald case, McDonald versus City of Chicago. And then more recently, this Bruin case, New York Rifle and Pistol Association versus Bruin. And the Heller case, instead of interpreting the Second Amendment to have 27 words, Justice Scalia, for whatever reason, decided he needed to look at the last 14. Well, on the face of that, that's ridiculous. An English sentence, no English sentence is interpreted by simply cutting off part of the verbiage and interpreting some other part. I mean, you wouldn't pass your first level English course in middle school if you told the teacher this is the way you're supposed to read an English sentence. And of course, it couldn't possibly be true for a legal document. I mean, how many times has the Supreme Court said every word in the Constitution has to be given an effect? You can't negate one word with another word. There can't be these inconsistencies. The whole thing was meant as a coherent whole to be interpreted, as such. All right? Well, okay. So the very basis of that Appel opinion is wrong. All right? And I would think someone as clever as Scalia could have figured out how to do it the right way, but I don't know why he did it the wrong way. But he did it the wrong. Maybe it was because of the way the case was presented to him. It was presented to him on this individual right theory, and they were trying to keep away from mentioning the militia, although District of Columbia has a militia. They certainly could have raised this point, based upon what the law was in the District of Columbia at the time. But anyway, he does that. But the real problem there is not simply that the opinion is fundamentally based on a foundation of sand. He comes up with these two really poisonous concepts. The first one being M16 rifles and the like. This thing that they're talking about, only these handguns and M16 rifles and the like, whatever and the like might be. Oh, well, maybe they're not protected by the Second Amendment. That's number one. So he opened up that can of worms. Then he also opened up the can of worms of the sensitive places. Oh, there are places where the Second Amendment doesn't apply, or there can be regulation of some kind that infringes on the Second Amendment rights. Well, why did he raise those 2 points at all? The theory is that he did that in order to get the fifth vote from Justice Kennedy. Kennedy is this guy who was kind of wishy-washy. Sometimes he'd be liberal, sometimes he'd be conservative. You could never tell with him. And you can see them in the back room. Kennedy said, well, I'm not going to agree to anything. We'll have these, it's all guns. Okay, well, let's put in this language, M16 rifles and the like, and see where that goes. And I'm not going to agree to let them carry a gun. Okay, let's put in this concept, sensitive places. You go to the Second Amendment, there's no asterisk that talks about sensitive places. There's no asterisk that talks about M16 rifles and the like. You can bet your bottom dollar that if the Founding Fathers had M16 rifles to arm their militia, the militia would have had M16 rifles and the like. All right? It's an absurdity. But there it is. Now, the interesting thing about that is the case did not involve rifles at all. M16s, the like, or anything else concerned with rifles, or shotguns, or bazookas. It involved a handgun, a semi-automatic handgun, probably a 9mm, I guess. I can't remember if they said what the caliber was, that Mr. Heller wanted to keep in his home, not even to carry on the street. So everything else that was said was what they call dicta, unnecessary to the opinion, and therefore theoretically without any legal effect at all. I mean, strictly speaking, in constitutional law courts or litigation courts, the instructor will say, well, you can't quote that dicta. Or if you do quote it, you've got to put in a parenthesis after the citation, dicta. This was not necessary to that opinion. And it may have been some, by the way, that, it does make sense or whatever, so we can say, this justice once said this, but it was not something that is actually a decision of a court, Supreme Court in particular. So this was dicta. Why did he put this? Why did he put in dicta? Well, it was a political deal. Scalia was not some first-year law student that didn't realize that you could put in dicta with no consequences. Same thing with the Bruin case, which they're all hailing because it overturned, for a millisecond, it overturned the concealed or the carry laws of New York City. And then no sooner did the case come up than the New York legislature passed new law, which is even more stringent and stupid than the one that had been originally overturned by the Supreme Court. But that was, again, it's one of these sensitive places. Oh, sensitive places. But there's no asterisk in the Second Amendment that talks about sensitive places. And so what the New York did, we'll make everything a sensitive place. We'll expand this concept to include all these areas, and as a result of that, there'll be hardly any place where a person can carry a gun in New York City. And then we'll also say that you can't go into a place unless the owner has approved it. It has to be like a sign on the door, say, concealed carry legitimate here. Make it even more difficult. We'll get all the private businesses on the side of gun control, because if the private businesses won't do it, then the gun control prohibition takes play. Whereas the real way to do it with a constitutional right would be to say, oh, if you're in business open to the public and this individual citizen has a constitutional right to carry a gun, the only thing you can do is to put a sign on your door saying you don't want people carrying guns in your business. Not the other way around, all right? So they did everything they could in New York to make the decision in the Bruen case a non-entity. Well, those two things, and everyone still did. Second Amendment proponents, these were the greatest cases in the world. Thank God for them. They were horrible decisions. And I think of the Bruen case in particular because the point that Thomas makes, now we got the two conservative twins, Scalia, rest in peace, and Thomas. Thomas writes about how we have to look at tradition. What were the traditions of gun regulation in the past to decide whether the things that are going on today? Well, tradition has nothing to do with it. The law may have something to do with it. We're talking about legal questions. We're not talking about traditions and customs. Because traditions and customs could have been illegal. We had all sorts of traditions and customs. Jim Crow, segregated schools, which eventually the Supreme Court said, hey, you can't have that. That's been illegal from forever. They should never have done that. But they were the traditions, right? They were the customs. So they can't even get that right. But the thing that amazes me about the people who expostulate on the brilliance of and worthwhile nature of the Bruen case. Well, Thomas finally said this about, you got to look back, baloney. 1880, I can't remember the way, 1880, somewhere there, Maddox versus United States. You can find cases all the way back in the 19th century saying the same thing, saying it better, because they all refer to, you have to look at the law at the time these things were done. What was the law when the Constitution was ratified? What was the law when the Second Amendment was ratified? So that we can determine what these figures of speech, what these terms actually meant by looking at the laws of the time. What was the right of the people to keep and bear arms in 1792 and before 1792, going back into the 1600s, with relationship to a well-regulated militia? And that was everybody had to have a gun that was appropriate to militia use. All right? That was the law. And it went back as far as you can find those laws, enactments, ordinances, whatever they call them, being put into play by the various legislatures. They gave them different names as well, depending on what era you were in. And there's no debate about that. The selective service system, 1947-48, they were trying to justify a peacetime draft. Because you got these people in the Army, and people you always have to be suspicious of standing armies. They wanted to have a peacetime draft to keep up the numbers, Army, Navy. And so the selective service system, they said, well, we can get away with this in time of war, which I don't think you can, but we leave that aside. But how do we get away with this in time of peace? How can we have a peacetime draft? So they commissioned 14 volumes long, an introductory volume, and then 13 volumes, one for each of the colonies and then the independent states, in which someone went apparently to the Library of Congress and they pulled out compilations of statutes, most of these printed in the middle 1800s of the colonial period. Dealing with the militia, right? Not with a standing army. There was no standing army. It was the British Army, right? The states could raise their own troops, but they hardly ever did. The militia. And, of course, what they discover when they find all of these statutes, and they didn't find all of them, by the way. I read through everything in that compilation. They didn't find all of them. There are a lot of them that are under other names. They're not called militia statutes. They're called something else. But what they did discover was, this was compulsory. Everyone from 16, in Massachusetts it was 15, 17, up to 45, 55, maybe 60 years of old, depending on where you were. They were compulsory members. If you were able-bodied, you were and a male, and not a slave. Obviously, a colonial period, they had slavery. And women were not involved in many aspects of what we call defense. you were compelled to be a member of this organization. It was a draft organization. You had no choice. And from this, they argue, or tried to argue, that therefore the Army could be peopled by draftees. Even though if you look at the Constitution of the United States, the Army and the militia are in two separate provisions of congressional power, and the Army and the militia are considered separate entities with respect to the president's authority as commander-in-chief. So they couldn't even get that straight. But the short answer was, anyone who's actually looked at this realizes this is what you do. Correct interpretation, or in the case of the Selective Service, incorrect interpretation, at least they tried to use the right method. You go back and you look at what the laws were at the time, and that gives you some insight as to what the provisions of a constitution might mean. Okay. So we don't have that. And as a result of that, we're in this mishmash where everything to do with the Second Amendment or the various state provisions that are equivalent is being twisted out of shape to fit the template of the individual right. Now, granted, if you're a member of the militia or subject to being in the militia, especially if you have to have a gun, which would be the rule unless you're a conscientious objector, what could you do with that gun if you were attacked? Could you use it for self-defense? Well, one would think so. You will never find an example with someone with a militia gun or having a gun because a militia statute told him he had to have a gun, was told that he couldn't or was penalized for using that gun for self-defense. That doesn't exist. I've never found one. No one has ever pointed that out. Never, never, never. All right. So obviously you had a quote unquote individual right that was connected to your individual duty to use that gun for other lawful purposes, the ultimate lawful purpose being self-defense. All right. The natural right that Blackstone says cannot be removed, abridged, etc., by any law of society. Although these laws, the gun control laws, do attempt to remove the right of self-defense. So they violate even the primordial primary right of natural law. It's a bunch of crazy people that we're living with these days. All right, but so the individual right concept is not contrary or inconsistent with the militia duty concept. In fact, they go together because self-defense, the theory of self-defense is that you, defending yourself in this situation, are in fact executing the law, because there is no policeman, constable, whatever judge there to interpose himself between you and the person who's trying to kill you. Right? And you are absolved of guilt in this situation for exactly that reason. You had no other choice but, in the face of imminent danger, to take action perhaps rising to the level of killing the assailant. And you cannot be punished for that. You were the executor of the law. You were performing that militia function in a one-on-one situation. So there's no difference between the militia concept and the individual right concept, except in the minds of these people who are fixated with this individual right concept because they can't think beyond that. But here's the real problem of this. If you think about the militia structure, and again, I go back to start off with Virginia, Article 1, Section 13, Virginia Constitution, a well-regulated militia. Now, they're defining a well-regulated militia, composed of the body of the people trained to arms. All the people trained to arms by whom? Well, by the state structure. They don't go off and train themselves. Is the proper, natural, and safe defense of a free state, therefore the right of the people to keep and bear arms shall not be infringed. You look at that right there, the proper, natural, and safe defense of a free state. That's the essence of the mindset that people should have and would be inculcated in them if they were members of the militia, because this is what they've been told. The reason you're here, the reason you can be drafted, the reason you're required to be trained to arms, the reason that you're required to have a gun, unless you're a conscientious objector, is so that you can perform this function. You can provide the proper, natural, and safe defense of a free state. So let's look at this. What do you mean by proper? Fit, right? Something that's appropriate. And why is it appropriate? Well, because it's natural. And come back to natural law, the right of the people, right? And it's safe because we can't depend upon standing armies and professional police forces, which are mini standing armies. They are untrustworthy. They have been untrustworthy since ancient times. The Greeks talked about this, right? And it's all in defense of a free state. Well, what is a free state? Well, we can now start talking about that. Personal liberty, economic freedom, all the freedoms of the Bill of Rights, whatever, how far you want to go in detail. So what would be taught by militia service, and it would start in Virginia actually before 16, because 16, you're subject to all the duties of the militia. You could be called out by the governor and, sent off to repel the Chinese women's army and lose your life. So you'll be trained in the schools, one would think, at 15, 14, 13, maybe 12. 12 is not too young to be teaching someone how to shoot a rifle, right? Teaching someone about the concept of a free state. What in heaven's name is that? Why does it matter? Why are you a part of it? Why do you have a responsibility to perform the proper natural and safe defense of this entity? Of course, you do the same thing with the Second Amendment. Well, regulated militia being necessary to the security of the free state. Why is it necessary? Well, because what are the alternatives? The alternatives are unsatisfactory. And then you get into the same concept, a free state, it's the same term under both of those provisions. So you'd have whole generations of people starting off pretty young in the schools. And it would be mandatory in the schools because, hell, by the time they're 16 years old, they're going to be performing this function. They better well know what they're getting into or what they're being put into. Right? We don't want someone that's never heard about this turning 16. The next thing he knows, he's going off to some kind of militia training function and not understanding what he's doing or why he's there. All right? Well, now, imagine how this would change the entire atmosphere in the public schools alone. If those were required courses to be taught from the top, 12 years old and up, 10 years old and up maybe, because you might be talking about the 10 and 11 years old, you'd be talking about American history, legal history, Constitution, Declaration of Independence, Articles of Confederation. 10-year-old child can understand some of that. Right? Oh, the teachers' unions wouldn't allow that, would they? Well, you get rid of the teachers' unions. That's one of the first things you need to do. But it would change the whole complexion of the public educational system, all the way up through at least the state community colleges and colleges, state universities. I remember even when I went to Harvard, they had a Reserve Officers Corps courses, Navy, Army, Air Force. All right? And that was because of private school. But those courses in the public schools, public universities, they would be there, and you'd probably make them mandatory. At least 1 year out of the two, or one semester out of the two, you have to take one of those courses. All right. Why? Because you're in this until you're 55 years of age or 60 years of age, whatever those limits are. So it would completely change the political character of this country from the childish idiocy that it is now to something extremely serious, because people would be educated in what it meant to be the proper natural and safe defense of a free state. What a free state actually is. Why this is a free state, and maybe initially, what's wrong with the situation we have now that is turning us away from a free state, what we have to change, like teachers' unions. I mean, let's bring that. That would be one of the first things I would teach. Teachers' unions, we can't have those. All right. Well, so one would think that if you were a proponent of the Second Amendment, even one that is blinded, wearing the blinders of the individual right theory, you might look at the rest of the Second Amendment, the first 13 words, or you might look at the first section of Article 1, Section 13 of the Virginia Constitution, if you were a Virginian. You'd say, oh, my God, yeah, this is what I really need. Because if we have this, then we're not going to have any more problems with anyone talking about banning assault firearms or banning high-capacity magazines or telling people that they can't get concealed carry permits so they can defend themselves against adventitious attacks of homicidal criminals, and how we can protect our borders from invasions from whatever, the huge numbers of Chinese national young men and so forth that are coming into the country and going God knows where, and cartels and drug cartels, all of that business. would be solved, because the entire mindset and attitude and, what shall I say, vision of the people would have gone through this malicious organizational process, which would be the highest level of education in living in a free state. Because it's the only provision of the U.S. Constitution, I think it's the only provision, too, of the Virginia Constitution that really talks about what a free state is, or what is the purpose of the militia to serve as the defense of the free state. All right? A lot of other provisions in the Virginia Constitution that talk about common benefit, protection, security of the people, and so forth and so on. But the only one that really lays out the picture and says this is the institution that's necessary, that's Second Amendment, necessary, the proper, natural, and safe defense in the Virginia Constitution, is the militia. There's no other institution. It doesn't say the governor, doesn't say the legislature, doesn't say the judiciary. All right. So, and the reason is because, of course, this takes you back to the Declaration of Independence. What does the Declaration of Independence say is the source of all government? Besides the laws of nature and nature's God, it's the ultimate source. But it's the power of the people to delegate just powers to their government. And when that governmental structure fails to exercise those powers in a just fashion, or arrogates to itself unjust powers, powers that even the people couldn't give it, and it no longer becomes a free state for that reason, then it is the people that have the right to alter or abolish it. And how are they going to do this necessary task unless they are appropriately organized in the very institution that is, to quote the Virginia Constitution, the proper, natural, and safe defense of a free state? So you see how the whole thing ties together. And there's no way you can unravel this intellectually. And then it all comes back to these clowns in the legislatures and the clown governors and the clowns on the media presentation, the talking heads, these idiot talking heads on The View and God knows where else, who are promoting what they consider to be gun control when they're really promoting structural inroads or inroads on the structure of the free states, the 50 free states, and then the big free state called the United States. They don't realize, well, some of them I'm sure do. I mean, I can't believe that some of these people are not conscious agents of cultural Marxism and they want to see this country destroyed. But most of them are just useful idiots, as Lenin would say. They don't understand any of this. But I think of that Presser case as an example of a situation where one would say, all right, you have a state legislature passing these laws, and maybe a governor, have to have a governor approving them, so they become a state statute, the effect of which is to prevent Congress from being able to call forth the militia from that state, whatever it is, Illinois, California, New York, so as to perform the functions necessary, execute the laws, suppress insurrections, or repel invasions for the United States. And the Presser decision says, well, that's completely wrong. That's a violation of the duty of these states. And when he, of course, talking about the states, are really talking about the instrumentalities of those states to do these things, the legislatures and the governors. All right. So now we run to the question of what is the consequence of the legislatures and the governors doing those things? Is that a conspiracy against the constitutional rights and duties of the citizens of those states, preventing those citizens from performing their duties to the government of the United States? And if it is, my goodness, if it is, then is it not punishable under the federal statutes, 18 U.S.C. sections 241, 242? Right? Action taken under color of law that violates the constitutional rights of individual and whole classes of individuals, every individual in the state that might be called by Congress, his constitutional right and duty to have a gun to perform that function has been taken away by these criminals in the state legislature? Well, I don't know. I mean, I'm just kind of speculating about this. There seems to be a better case, though, for that than there is for saying Trump is disqualified from office. Well, but the Second Amendment people, they never get into that. They never look at these statutes and say, wait a minute, there's a fundamental problem here, and it's not that you're violating the individual right of an individual an individual right of an individual to have an individual gun for individual purposes, because there are really no individual purposes involved in this. It's this much bigger thing. This is a conspiracy not only against me, Joe Dokes. I can't buy a assault firearm now because of this stupid statute, but it's a conspiracy against the entire population of this state and a conspiracy against the United States. Be able to defend this country in the sense of repelling invasions. Right? Oh, my goodness. Now that's a much bigger picture. Now, of course, then you'd have maybe a more, vitriolic dispute among the crazies in the media and the cultural Marxists and the individual Second Amendment proponents and so forth. But at least it would be on the right level. And the cultural Marxists and the media people say, oh, well, you got that gun. Somebody's going to go shoot up a school. Yeah, well, okay, well, that's a terrible thing. Somebody's going to shoot up a school. Of course, the police hide outside, right? Uvalde, right? The wonderful police that are supposed to protect us. We don't need a gun because we have the police. But when the shooting starts, they're hiding behind the police cars in the parking lot. All right? That's the reality of the situation. Well, we leave that aside, okay? But the real problem is this higher level problem. Guns are not in the hands of people simply so that people can have guns in their hands. They're in the hands of the people so that people can serve in the militia. The militia does not exist simply as a group of people that runs around in the woods shooting at targets and so forth, wearing camouflage outfits. They're there for this ultimate purpose, the proper, natural, and defense of a free state, says the Virginia Constitution. It's necessary to the security of a free state, says the U.S. Constitution. And that takes you all the way back to the whole fundamental underpinning of the system, which is the Declaration of Independence. Oh, so it's a hell of a lot bigger. And that's why I look at these people who are the individual rights people, and I say, oh, my goodness, they are doing such a tremendous disservice because they're taking this whole argument or area of argumentation down into this dark cavern where they're fighting off the bats of cultural Marxism and the nitwits of these television talk shows, internet talk shows, internet blogs, and so forth, and arguing back and forth about how many rounds there should be in a magazine, right? Whether if you don't have a pistol grip on a rifle that has other characteristics, then it is no longer other of the banned characteristics. If you don't have the pistol grip or you don't have the bayonet lug, then it is not an assault weapon. Or what difference does it make that it has a bayonet lug to make it an assault weapon? How many people have been killed, if we want to use that kind of statistic, have been killed by rifles with bayonets in the United States in the last 50 years? So why is it there, right? Well, it's there specifically because the people who are writing that are looking to the possibility of the gun could be used in a military context. They are specifically preventing people from getting the guns that would be used in the context of a militia service. That's the only reason a bayonet lug would be there. The average individual doesn't use a bayonet lug going hunting, doesn't use a bayonet lug defending himself in his home, assuming he would defend himself with that type of a firearm. It would be the actual military service, or paramilitary service, if you will. So you see the picture here. And the Second Amendment proponents now, they miss that entirely. And you can ask the question yourself as to why they do, and all sorts of historical reasons for it. I think the primary one was when they finally woke up to the fact that gun control was dangerous after 1968. Gun Control Act in 1968. In the early 1970s, they said, we don't want to mention the militia because it's going to make us look a little crazy. Guys running around the woods with guns. We want to limit this to personal defense, because who can argue against personal defense? Who can argue against it? Well, the same people that are arguing to pass these laws are arguing against personal defense. Every one of their damn arguments is, oh, you don't need this gun for personal defense, right? Although there are situations where you very well might need it. And then you hear these idiots like Whoopi Goldberg was on there one day saying, you don't need these guns. What happens when you shoot a deer with one of these assault rifles? The deer blows up or something. She doesn't know what she's talking about. In fact, the old 30-30 lever action carbine is probably, from a ballistic point of view, a far more dangerous weapon than a .223 AR-15. But let's not talk about facts, right? Let's not talk about reality. And so these are the problems. As soon as you go down that rabbit hole of individual right, the whole thing is my right to have some, then you get into all of these irrelevant or erroneous arguments, all of which disappear. Oh, a 223 is the most deadly cartridge. That's why we want the militia to have it. Right? Oh, 30-round magazine, you can fire, so many rounds a minute and reload. That's why we want the militia to have it. Every one of those arguments disappears. The whole panoply of gun control is gone. Plus, the more important thing, in my view, the point I'm making here, is that as soon as you start talking about the militia as being the causative factor in this argument, then you realize there is this much bigger issue at stake. The organization of people for this purpose and their education about this purpose. And that's what we fail today. We've got a lot of people who are, constitutionalists, whatever, people who you would consider to be, I don't want to call them right-wing because I don't know what that means, in favor of a free society based upon a limited government with protection of constitutional rights, etc. All right? All of those people would now be speaking with a single voice in an organizational structure. And how many times have you seen people on the internet say, oh, the problem with our side, quote unquote, our side, the people who are in favor of this kind of society, is that we don't have real organization. We're broken up into little groups that each one has its own talking points, whereas our opponents, the cultural Marxists, oh, they speak with a common voice. They're all well organized. They're well funded. They know what their goals are. And I say, yes, that's right. Obviously they do. It's always been the case with those people. And obviously the other side is also true. People on our side are not. And yet here is the one thing that could organize all of them for a central purpose. Because I would even think that people who were pacifists, right? You're a Quaker, you're a Mennonite, you're Amish, whatever it is, that's fine. You're religious, maybe you could be a philosophical pacifist. Pete Seeger had a famous Supreme Court case where he claimed he was a philosophical pacifist and therefore was not subject to, I think it was the draft. Supreme Court said, yeah, you could be a philosophical, not necessarily a religious pacifist, but people who are pacifists. They could agree to this. They could say, yes, we won't do that. We won't serve with a rifle. There are other things we can do. We could serve in a medical unit or communications or something. We could do something that doesn't have anything to do with potentially taking life because we are pacifists. But we certainly want to live in this kind of a society. And if this kind of society demands, as our founding documents tell us it demands, this kind of a structure in which all the rest of you people are going to participate with arms, then we're in favor of it. The only people who would not be in favor of the cultural Marxist people who want to destroy the country. And, of course, the purpose of the militia is to stop these people from destroying the country. So we don't care about them, I would hope. You don't care what their opinion is. And so I look at this, I'm 80-something years old, right? And I'm looking at this and saying to myself, I've been dealing with this since, 1970s, late 1970s. What's that, close to 50 years? And it's gotten worse every year. So at some point you have to stand back and say, well, maybe this roller coaster has gone over that final hump and it's gravity's taken over. There's no way to pull it, no way to stop it till it hits rock bottom. I don't know. But I just look at the situation here in Virginia, not that it's terrifically worrisome. There's a whole laundry list. There's one of the Virginia Second Amendment groups sent an email the other day listing all of the gun control bills that the Democrats had passed, not just proposed, but passed. It was on per page on this website, or on this email. And, of course, they're saying, well, the governor is probably not going to approve these, but in any event, let's everybody contact the governor and encourage him to veto these bills. That's really, it's gotten to that point where if this one man, this Republican governor we have, doesn't stand in the breach, all of this tidal wave of fundamentally anti-American, anti-constitutionalist, anti-Declaration of Independence legislation is going to sweep over the state of Virginia. And I'm quoting, when I quote you the state of Virginia Constitution, who wrote that this thing was adopted on June the 12th, 1776 originally, before the Declaration of Independence? Right? Who were the main leaders in the whole country with respect to everything that we talk about the Founding Fathers? Well, they were primarily people who came from Virginia. Madison, Mason, Jefferson, you run down this list, Washington. All right, Virginia was kind of the epicenter of that. And yet I'm looking at this, it was yesterday. I opened up this email. This is happening in Virginia. We're hoping that one man this tidal wave is coming at us from these crazy Democrats, and we're hoping that this one, Governor Youngkin, the Republican governor, is going to veto all of these bills. Well, one hopes that he will. Actually, there was one or two bills in there that went too bad. One of them, you couldn't leave a loaded gun where a minor child could get it. It was going to be a penalty if a minor child got his hands on a loaded gun and obviously did something with it. Otherwise, how would they know? I said, okay, that's fine, but that's gun safety. I've been a firearms instructor for many years, and that's one of the first things we teach. Keep firearms and ammunition out of the hands of unauthorized persons. Who are those people? Oh, number one, it's children. Right? Unless you have them at the range, unless you're training them or something, you don't let them have firearms and ammunition by themselves, obviously. Okay, so here was a statute that wanted, I guess, to increase some penalty under Virginia law. I guess one could say that's a gun-controlled statute, but on the other hand, one would say, okay, that's fine. I wouldn't want the governor necessarily to veto that one. So one does have to look at these things with a certain amount of circumspection. But the ones that were consequential were the ones dealing with assault firearms and who could buy this, who could buy that, who could carry here, who could carry there, or not carry. That's a better way to put it, right? Sensitive places, they play in that game, all right? All that stuff. And you look at that and you say, my gosh, this is what we've gotten. In the Commonwealth of Virginia, which historically was, in a sense, the intellectual birthplace of so many of these ideas, or at least it brought the ideas to the fore and put them into the proper language, the crux of the whole American system. And this is the one where all you have to do is have an election where the Democrats get a 2 or 3 vote margin in each one of the houses of the General Assembly, and you have Marxist chaos. And how did they get there? How did they get there? The people voted for them. Now, I ask the final question. We can stop here. Would we have people voting this way if we had been following the basic constitutional principles and in our statutes had required that the militia were actually functioning the way they're supposed to function? I would be willing to bet a very large stack of Kruger ants that the answer is no. You start educating people from 10 or 12 years old on up for what they're going to do from the time they're 16, and then they come through every year or so with every 2 years with some kind of training in the militia until they're 45 years old, and then they go in the reserves. So you can imagine how this would be set up in a logical fashion. You go through that, you will have a free state. Because ultimately, the cultural Marxists will not want to live in that kind of situation because they'll be called to duty as well.
Yeah, and that's exactly why the educational system of the United States was designed as the public education is to support cultural Marxism and to not allow exactly what you're describing.
That's right. That's right. So we solve that problem by putting something else in place of it, and you drive the cultural Marxists out. They just leave.
That's where we just interviewed Alex Newman, contributor to Epoch Times, talking about the critical nature of getting children out of public schools where they're being indoctrinated to be cultural Marxists and to restore one family at a time, getting our heads on straight and getting our feet on the ground. You've given us a very solid framework to change, to shift the debate, to shift the discussion. Whenever any of us gets involved in or sees on the news or hears our legislature getting embroiled in one of these rabbit holes that you've described, very clearly and eloquently, that are completely missing the point of what the Second Amendment is about, what the militias are supposed to be, etc. It gives us a basis for talking intelligently with others about that. it's going to be a challenge, as you've described, going forward. Maybe the roller coasters over the hill, you say, trying to find the right venues, the right ways of connecting like-minded people to have this discussion at the right level, and to prevent this kind of redirection and distraction of these false arguments, these straw man arguments that end up leading nowhere, that we need to get out of the way so that we can have the real discussion. Dr. Vieira, you've always been a source of clear thinking, and as well as your background of knowledge that you bring of the historical precedents and the importance of that to these issues, to make sense of them rather than the nonsense that we're hearing in the public square. We're grateful for that, and if people want to follow your work on either the Second Amendment or the lawfare attack on former President Trump and presidential candidate Trump, where should they follow your work?
Well, right now they should go to News with Views, one word, newswithviews.com. In fact, I have a couple of recent articles up there dealing with exactly that lawfare question.
Well, thank you, Dr. Vieira, for joining us again on Liberty and Finance and bringing these important topics before our listeners and our subscribers so that we can elevate the conversation above the mire that it otherwise gets into and the neglect that it falls into in the hands of either our legislatures or our media. But with your help, we're trying to bring a different level of awareness about this to more hearts and minds, and we appreciate your part in that always here on Liberty and Finance.
Well, thank you for the opportunity. Appreciate it.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for March 11th through March 18th, 2024, while supplies last. First, we feature 90% junk silver mixed dimes and quarters at just $1.99 over spot. We also have AU pre-1933 Gold Liberty at $65 over a 1-ounce spot. And finally, we're offering our choice 1-ounce palladium bars at just $119 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.